Great. And I'd like to welcome everyone again to this Wisconsin Special Education Mediation System webinar on dispute resolution options. My name is Courtney Selzer. I'm the Executive Director of Wisconsin Facets, and I represent the parent partner on the Wisconsin Special Education Mediation System project. With me today is Nissan Barlev. Nissan is the Director of Special Education for CESA 7, and Nissan represents the school partner on the Wisconsin Special Education Mediation System project. We know that issues and conflicts and disputes sometimes do arise related to the planning or the implementation of IEPs for children with special needs. The Wisconsin Special Education Mediation System, that's a mouthful, so we shorten that to WSEMS, has been helping parents of children with disabilities and schools resolve these disputes for free since around 1996. Our workshop today is going to do a couple of things. First, it's going to give you some general information about WSEMS and the various free options that are available to parents and schools to help resolve disputes early. Next, we're going to give you some information about how you can access each of these options. And last but not least, we're going to finish with a little bit of information about some of the results and outcomes that the system has achieved over the past 25 years. So with that, I will turn things over to my co-presenter, Nissan.
Thank you so much, Courtney, and good afternoon, everyone. The Wisconsin Special Ed Mediation System has been funded by Wisconsin DPI with a federal grant to CESA 7 since 1996. And for all these years, the goal of the grant has been simply to administer the Wisconsin Special Ed Mediation System throughout the state. And what that means is that to provide a roster of neutral to assist in the resolution of dispute between parents of students with disabilities and school, to provide training and outreach about the system, how to access, how to use it, just like we're doing today, and to collect longitudinal data for ongoing evaluation of our system. That is our quality control. WSEMS is a unique system that has been nationally recognized by the Center for Appropriate Dispute Resolution in Special Education, CADRE, as one of just 4 state systems that were considered extremely effective in its use and outcome, meaning high agreement rate. WSEMS was selected also because of our successful involvement of stakeholders. In fact, our system was designed by a 17-member group of key stakeholders, half of them representing parent groups and half of them school groups. That stakeholder council still exists today and continues to serve as a collective advisory body for the system. Our system is also unique nationally because it is led by a team that models partnership and provides oversight to the system and includes a school partner, that's me, that I'm the Special Ed Director of CESA 7, representing 38 school districts. And on WSEMS, I represent the school perspective, as Courtney mentioned. I'm also one of the founders of WSEMS, along with Courtney Salazar, Wisconsin Facet Executive Director, who is a parent of 2 children. Courtney is the parent partner on our team and represent the parent perspective on our team. Gia Pionic is our mediation partner, and she provides the dispute resolution expertise to our team and is also the system administrator and intake coordinator. When you call WSEMS, she's the person who you speak with about the concern, issues that you have. She explained what is involved in accessing mediation or IEP facilitation. She assigned the cases to mediators and to the facilitators. Now, Senior Ramos is a parent and an associate director of Wisconsin Facets. And she's also our multicultural outreach coordinator. Now, Senior converted the WSEMS website into Spanish, as well as other materials of WSEMS. Besides the high agreement rate and intense stakeholders' involvement in which we are nationally recognized, Wisconsin also is one of the first states to provide for a neutral facilitator for IEP team meetings, an option that is not required by IDA 2004. However, we believe that when more options are available to resolve disputes between parents and schools, the better. We also provide a facilitator for the resolution meeting and will be describing that at a later slide. WSEMS established continuous quality improvement practices to our system, including participant surveys, ongoing training for the roster, and feedback from our stakeholders. At this time, we're also offering for virtual or in-person IP facilitation, mediation, or resolution meeting. As we move to the next slide, you see a diagram of the options in Wisconsin of dispute resolution. And these are those 4 options that you see in the dark blue arrows. Parents in school will have control over the outcome as they are working together to solve the issue. It's called self-determination. The informal meeting, which is the first arrow on the left, is not a process provided through WSMS. It is simply a recommended meeting between parents, classroom teacher, principal, or special ed director. While it can be used at any time, it is especially effective if used early in the relationship between the parent and the school. As we mentioned earlier, the other 3 dark blue arrows are all available through the system: IP facilitation, mediation, and the resolution process, sometimes called resolution meeting. In all 3, WSEMS impartial mediator or facilitator can help the parents and school work together to reach an agreement that meets the educational needs of the student. And we will shortly describe each of these 3 options in more details. Common denominator to all these 3 options: they all start with the intake case by Gia Pionic, our intake coordinator. They're all voluntary. Both parties have to agree to it, and they're all free to parents of students with disability and schools in Wisconsin. As you move from left to right on this diagram in front of you, the light blue arrows indicate processes that are available in Wisconsin, but not through WSEMS, and where the control of both the process and the outcome shifts away from the participant to someone else. For example, an IDEA complaint will be decided by Wisconsin DPI staff, a due process by an administrative law judge, and litigation by either a judge or a jury. Thank you, Courtney.
Thanks, Nissan. So no matter which option you're interested in, whether it's the facilitated IEP, the mediation, or a resolution meeting, they all start with an intake process, and that's what's on this slide. So let's start with the red box on the top left. So that box represents when a request is received for any of the 3 options. You make your request directly with the system, and it goes to Gia Pionic, who handles all of our intake. We like to point out, just to make people feel more comfortable, that Gia has no affiliation with any parent or school groups. She's not a parent of a child with a disability, and she has also never worked for a school. And why that's important is because we want parties to feel like their request is getting an impartial start, that Gia is impartial and she is able to work with both schools and families. So as we move down the slide to the purple box on the bottom left-hand corner, this is where Gia is going to do a thorough case intake. So it includes things like screening, and screening is where Gia is going to gather, information about the child, their name, their age, their grade, their school, their disability, and contact information for the school and the parent. Gia is also going to spend some time working with the parties and answering any questions that people may have. and also helping to kind of educate people about the different processes that are available through WSEMS. She can also provide information about the neutrals that we have on our roster. So these are, the mediators and the facilitators, if people have initial questions about who those individuals are as well. And then Gia is going to take all of this information that she collects, and she uses that to help determine if in fact this case does meet the legal criteria for WSEMS to be able to take the case on. So assuming it does, let's move over to the blue box in the bottom center. This box represents the process of educating the parties a little further, answering questions, and really where Gia is helping both the parents and or the schools, feel better prepared to make their own decisions about what happens next. So then as we move up to the green box in the middle of the slide, this box represents when the parties feel like they have enough information from Gia and that they feel comfortable making a decision about whether or not they still want to continue to use the system, and assuming that they do, which process they think is going to be best for their particular situation. So that brings us then to the final set of boxes, those orange boxes on the right side of the screen. And each of those just represents the 3 different options that WSEMS has available. And we're going to talk through, as we get further into the workshop, we're going to talk through each of those options. But before we do, we tend to get a lot of questions about who the mediators and the facilitators are. And so just to give a little bit of context, in some states, there are really just a couple of mediators and facilitators that are used to do these types of mediations or facilitated IEPs. Other states may have many, many, many of them. Some states may use a mediation center. Other states use administrative law judges. Some states even use their own state employees. Here in Wisconsin, we use a roster of around about 20 neutrals who are contracted directly through our system. So these neutrals are not our employees, they're simply contractors. And we use the same roster of individuals for mediations, for IEP facilitation, and for resolution meetings. We like to point out that a really important thing to us about our roster is that the neutrals that we have on our roster are not employed by an SEA, so that would be DPI, or any local education agency or school district. And in fact, if any member of the roster were to become employed by a school district or DPI, they would have to become inactive on the roster. Likewise, none of the neutrals on our roster are either employed by or on the board of any type of parent advocacy organization. And again, should their status change, should they become employed by a parent organization, should they join the board, then they too would have to be moved to inactive on the roster. And the reason that we do this is, again, because we want our neutrals to be as impartial as possible, and we want the people on our roster to be attractive to both schools and families. We are often asked, well, how does someone join this roster? It's a pretty intensive process. We do not add new people to the roster every year. We do this every 5 to 7 years or so. It starts with an interview and application process, and from there, the people that pass through that phase are invited to a pretty intense 5-day training where they get a lot of information, not only about dispute resolution, but also about special education. And this training is important because it gives us the opportunity to kind of watch them in action, to see what their skill set looks like, and if they might be individuals we'd be interested in adding to our roster. Essentially, we are looking for a really diverse group of individuals, both in terms of demographics and experience. And then once on our roster, all of our neutrals are required to attend an annual one-day update training. And this makes sure that they are staying current on any changes in the law or current topics that are rising to the surface in the special education realm. When it comes time to select a mediator for a case, either party, so the school or the parent, can suggest a particular person that they're interested in using, and they can do this by writing the name of that neutral on the request form, or they can just verbally communicate this to GIA during the intake process. If the parties don't have a specific person that they'd like to request to be their neutral facilitator, GIA can certainly work with the parties to help them find a mediator or a facilitator who she thinks is going to be really well matched to that particular case. And then you do see the link on the slide to the website. Each mediator on our roster has their own bio. Some have pictures, some have videos. So we try to put out there as much information as possible so that parties can feel really confident making a decision about who to use. So at this point, I will turn things back to Nissan.
Thank you, Courtney. So IEP facilitation, as you saw in the previous diagram with the arrows, is one of the earliest options for conflict prevention that's available to our system. As we mentioned, IEP facilitation is a voluntary option, and if both parties agree to it, a trained, impartial professional facilitator from WSEMS roster will attend the IEP meeting, help the IEP team by facilitating the IEP meeting discussions. As we mentioned earlier, it is free service to all WSEMS participants. So as we move on to the next slide, so how can you tell if mediation or IEP facilitation might be a more appropriate option in this situation? So IEP facilitation is best to use when parents or school districts think that an IEP meeting is going to be difficult to manage, when there seems to have been lack of trust or problems are expected with communication, and before an impasse, before a stopping block, a brick wall has been reached. On the other hand, if there is a specific dispute, for example, a dispute regarding the use of one-to-one professional, or a dispute about the amount of speech and language services per week, such a dispute is more appropriate for mediation, as Courtney will describe shortly. The WSEMS stakeholder group determined that a facilitated IEP could be used for any IEP, whether it's initial IEP, annual, or a 3-year reevaluation. Given the group dynamic in a certain situation when both parties distrust each other, an IEP facilitation meeting can be more constructive and productive than one without an IEP facilitator from WSEMS. So the next slide shows us the request for IEP facilitation. You can see the picture on the right side. If parents or school district staff think that an IEP facilitation is the right option, then the parents or school staff or both can make the request for the IEP facilitation. They can contact WSEMS to request an IEP facilitation. They can obtain the request online or write or call WSEMS. A copy of the form with the contact information and the phone number is in your packet. When a request is made, GIA, intake coordinator, will describe the facilitation process as Courtney described before and answer questions. GIA will be available as a resource throughout this process. If one party requests facilitation, then GIA will contact the other party and they will have up to 5 days to respond yes or no. Because IEP facilitation is voluntary, if either party says no, then the IEP will be held without the use of our facilitator. If both parties agree to participate in an IEP facilitation, the meeting will be held at a time and place acceptable to all IEP team members and the facilitator. If a date has already been set for the meeting, GIA will find a facilitator who is available at that time and with whom the parties agree to work with. If the date has not been set, then the selected facilitator will work with the parents and school to find an acceptable date and time. In either case, the school district is responsible to send out the IEP invitation letter and adhere to all legal IEP timelines. When a request for IEP facilitation is made, that's the statement that's included in that request. It says basically, we are requesting that WSEMS work with the parties to choose a neutral facilitator from its roster. We understand, it continues to say, we understand that WSEMS pays the fees for the facilitator. We understand that signing the request gives the WSEMS facilitator and WSEMS intake coordinator access to information about the student, including information from the IEP document, disability information, school day schedule, etc. We understand the facilitator is not a member of the IEP team. And by the way, we will discuss this in shortly, describing the role of the facilitator. But in the request, it says, we understand the facilitator is not a member of the IEP team. We understand the facilitator cannot provide legal advice to any participant. So that was a statement in the request for IEP facilitation. As we move on now to the next slide. So here we'll talk about the participants. Participant IEP facilitation are the IEP team members who are normally required to be invited to IEP meeting, as well as the facilitator. However, as we said before, the facilitator is not a member of the IEP team and does not get involved in any content-related discussion, such as should the student, for example, spend more time in the regular education classroom, or should the student receive more than twice a day speech and language services. The next slide will describe in more detail the role of the facilitator. And there we go. So as you can see from the slide, and let's just go to some of them. The role is to assist in the IEP process, which means to keep team focused on developing the IEP document, clarifies points of agreement and disagreement, and maintain open, respectful communication. As you can see on the slide, helps team discuss specific steps of what will occur after the IEP meeting, offer ways to resolve conflicts, but makes no decision for the IEP team. Only the IEP team makes those decisions. So the role is to help the parties focus on the need of the child and develop the IEP by assisting with problem solving and discussion of mutual goals. Facilitator can clarify points of agreement and disagreement and reframe those points of disagreement into manageable discussion. Facilitator can help the IEP team discuss specific steps, what will occur after the IEP meeting, who does what, when, and where, and suggest ways to address future conflicts. Facilitator, and we wanted to emphasize that, makes no decision for the IEP team. Only the IEP team members determine all decisions related to content area, as we mentioned before. The next slide shows our survey, results of our survey. As we mentioned before, we use a survey as a quality control to make sure our system is responsive to the needs of parents and schools. As you can see from the slide, that with the total survey of a little bit over 2,300, that almost 90%, were satisfied with the IEP facilitation process. 89% felt that given opportunity to be part of the IEP process. and 82% thought IEP facilitation will improve future IEP meetings. Over 88.5% would use the same facilitator again, and 88% thought the facilitator was impartial throughout the process. And autism and EBD are the most common disability that brought about the request for IEP facilitation. Most common subject matters issue were placement, accommodation, and behavior intervention plan. So we wanted to emphasize that the information is given anonymously through the survey. No names are provided. It helps us review the process and see if corrections are needed. That's our quality control. It's also important to mention that we maintain confidentiality. For us, it is extremely important. And the only thing shared publicly, including to Wisconsin DPI, is the aggregate data like the one that you see on the slide, nothing beyond that. This information, the survey, is being analyzed annually by an outside evaluator, an out-of-state university professor who specializes in math and statistics. Thank you, Courtney.
Thanks, Nissan. So that wraps up the option for IEP facilitation. So next we're going to talk about the mediation option, which again is a separate option offered through the system. So in a mediation, you've got a trained impartial person, most often called a mediator, who is going to facilitate discussion and really help support the parties to reach their own agreement. This person is not a judge. They're not there to render any final kind of decision. They're there to really facilitate the parties working together to reach an agreement. Since IDEA of 1997, so that's the big federal special education law, mediation is the dispute resolution option that is required by both federal and state laws to be offered in states. And it's required, not only required, but it's also required to be free for both schools and parents. In your handouts, we've provided you a handout called the WSEMS Mediation Manual. This is a really cool resource to have, but this is one of those resources that when I cautioned you not to print certain things because they're really long and they might take a lot of ink, this is one of them. This is a fairly lengthy resource, and that's because the resource itself is divided up into several different sections. So there's a section on the overview of the mediation process, and then there's a section specifically for parents, a section specifically for school representatives, and then a separate section specifically for any attorneys or advocates who end up participating in the process. We think it's a really helpful tool, either if you're looking at pursuing one of the options or maybe if you're trying to get ready to participate in one. Another thing we like to mention about mediation is how important confidentiality is to the process. So there are both federal and state laws that talk about the confidentiality that has to be maintained during a mediation session. And we think this is really important because we hope that when the parties know that their discussions during the mediation are confidential and can't be shared outside of the session, that they'll feel a little more comfortable, maybe being more candid, maybe looking at things that are a little outside of the box in terms of solutions. What this also means, though, is that your mediator cannot be called to testify in any type of future court proceeding about what happened during the mediation. Nissan also mentioned to you how much we try to protect the confidentiality of the participants in the process. So we like everyone to know that besides GIA, there's no one who knows specifically which parents or which school districts are using mediation or facilitated IEP for that matter. We don't get a report of that. DPI doesn't get a report of that. We don't put that out publicly either. And then the data that we do share, well, you saw some of it on the last screen, is just it's data that's all been summed together and shared out. Also important to mention that no records are going to be kept by your mediator. So what that means is if you do reach an agreement during your mediation, the only people who are going to get a copy of that are the parents and the school district. So the mediator doesn't keep one, GIA doesn't keep one, you know, WSEMS at the office doesn't have a copy, DPI won't have a copy, so it's really important to make sure you hold on to that. And then just one point of clarification before we move on. If you have used a facilitator during your IEP process and you still think there's work to be done, you certainly can go ahead and still request mediation. So just using one of the options doesn't preclude you from using the other option. So when is it best to request mediation? Well, we think mediation is best used when there's a very specific dispute. And you know, Nissan referred to this as an impasse or a brick wall that you just feel like you're having a hard time getting past. Mediation is also good when the communication between the parties is not or has not been, you know, constructive or productive in the past. Again, if there's a brick wall that you're running into with regards to a particular issue, or if there's a strong history of dispute between the parents and school, mediation can be a good option. It is important to note that a referral for special education has to have been made in order for a case to be eligible for mediation. So that's really the big kind of screening thing that GIA will be looking for, is if a referral has been put in for special education first. And then a few other reasons why we think mediation is a great option. It provides the possibility for creative, flexible solutions. It's a very forward-looking process, so it focuses on the future instead of looking at the past and trying to blame people or things for where you're at. It's really, you know, pushes the parties to look towards the future. There can be a cost savings because issues can be resolved more quickly, and parties can also avoid the time or expense of preparing for or participating in, you know, other types of court type proceedings like a due process hearing. Another cool thing about mediation is that the parties are the decision makers. We mentioned before, your mediator is not a judge. Your mediator is there to help you as the parties come to an agreement. And because of this, we think that mediation also provides a chance to really preserve a good working relationship, which is important particularly if they're going to be, you know, the child's young or there are multiple siblings that still have to come through a particular school or district. But I think perhaps the most significant impact of mediation is really that it works to establish a collaborative partnership. And that partnership is going to be critical not only in resolving the current dispute, but we find that it provides parents and schools with a framework with which they can use to resolve future disputes. You know, because mediation is completely voluntary, you only participate if you want to. You can stop anytime you want to. If a parent requests mediation and the school does not want to go, there is no mediation. Likewise, if the school requests mediation and the parent does not want to go, there is no mediation either. It is a completely voluntary process. So let's move to the next slide. You've got a picture of the request form on the screen. You've also got a copy of the mediation request form and the facilitated IEP request form in your handout pod. A request for mediation has to be made in writing, and it has to be sent to the WSEMS office. Usually the quickest way to get a mediation rolling is through what's called a joint request. A joint request is when both the parents and the school are pretty much in agreement that they both want to go to mediation. And so they both sign the bottom of the form, and then it gets sent in. So that's the quickest way to get things rolling. But certainly you can always request mediation with a single request, and that's basically where either the parents or the school say, we want to go to mediation. They sign the form, they send it in. The reason this takes a little bit longer is just because GIA then has to take that extra step to contact the other party to see if they want to in fact move forward with the mediation. So you use this request form to make the request. There's a small space on here, that kind of white space on the form, which asks you to briefly describe the dispute. And when we say briefly, we mean it. Something as simple as transportation issues could be put in there. And the reason you can be so brief is because when Gia does her intake process, she's going to get all of the details that she needs about what's cooking. So you do not need to detail all of that on the form. Then in terms of scheduling, once a request is received and both parties say, yep, we want to move forward, the mediation is to be scheduled within 21 days. The mediator is going to work with the parents and schools to schedule the mediation session, and that mediator is going to be looking for a date, a time, if it's going to be in person, a location that's convenient to everyone. Some mediations happen at schools. We've had mediations happen at community centers, at conference rooms and banks, at libraries, wherever everybody's going to feel comfortable. Or as Neeson mentioned, we are still offering virtual mediations via Zoom as well. Mediation usually takes part of a day. Some parties may need an additional session if the issues are really complex. The average we see is about 4.5 hours per session. And when setting up the mediation session, the mediator generally is going to ask the parties up front to agree on how much time they have available. That may be a few hours or the whole day, but the mediator is going to want to make sure everyone is putting aside about the same amount of time to handle things. And then once the parties agree to participate in mediation, the next step is for them to both agree on which mediator to use. And we talked a little bit about, if you aren't sure, you can do some research on the website, or Gia can make some suggestions. So who participates in mediation? Well, in Wisconsin, our law provides that the mediation participants automatically may include 2 parents or a competent adult student, and 2 school representatives. And since the term school representative was not further defined, it's been interpreted that one of those school representatives can be the school's attorney if they desire. And then our law does say that other people can participate in mediation. The catch here is that both parties have to agree on who those additional people might be. So if there are any other people that the parents would like to have attend, whether it's relatives, an advocate, an attorney, a therapist perhaps, they can do that. It just has to be approved by the school. And then if there's any additional people that the school feels would be useful, so maybe some more of those IEP team members, a school social worker, someone like that, those individuals have to be approved by the parents before they can attend. If the parties have both been working with attorneys prior to the mediation, it's really usually better to have them attend the mediation. Otherwise, what tends to happen is that the attorneys will be consulted after the meeting or even during the meeting by phone or email. And since the attorneys have not been there to really be a part of the discussion leading up to that, it can take a lot more time to discuss what has happened. And additionally, if you do have attorneys at the mediation, they are actually able to give legal advice should there be a need for it. And remember, your mediators, even if your mediator is an attorney themselves, they are not allowed to give legal advice during the course of a mediation. So a little bit on what the mediator's role is. The mediator is there to really help the district and the parents decide, first of all, who's going to participate in the session. And once they've determined that and set the mediation up, then the mediator is going to spend some time to make sure that the participants know what they can expect from the mediation. The mediator is going to help facilitate and structure the discussion between the participants. And again, their role is not to impose some sort of judgment or decision. They can't give legal advice, they can't interpret the law. They are there to facilitate and structure constructive and positive discussion and communication, which hopefully will lead to an agreement at the end of the process. In terms of what actually happens during a mediation, for the most part, it's pretty informal. If you are in person, everyone tends to be in the same room. If you're virtual, everyone is in the same Zoom room. However, the mediator does have the ability to meet with participants separately. That's called a caucus. And if you're doing your mediation via Zoom, there's breakout rooms that the mediator can create if people need to speak privately with the mediator. Typically at the start of a mediation, the mediator is going to go over what's called the agreement to mediate. And I'm just double checking to see, I think that's in your handouts. No, it is not. That's because we didn't have enough space. It's in that mediation manual. So this agreement to mediate is not a form saying you agree with the outcome. It's just the mediator has everyone sign saying, yes, I agree to be here and to participate, and I agree to the confidentiality provisions. And then everybody signs it. As the mediation gets rolling, the mediator is usually going to do a little bit about explaining the process and their role. And then most mediators are going to ask the participants to explain, why they're there, what they would like to see as a positive outcome to resolve the dispute. And during this process, the mediator is likely going to ask a lot of questions, try to get some clarification. They're going to really try to facilitate some brainstorming and creating of options. During the mediation, there is no audio, video, or written record of the session. Again, that is related to the confidentiality provisions. All right. So if an agreement has been reached during the mediation, you need to reduce that agreement down to writing. And in the mediation manual that's in your handouts on pages 11 and 35, there's some guidance on this. Unfortunately, what we don't have is a specific form that you use to do this. And the reason for that is because each agreement is so unique and so specific to that particular situation, it would be kind of impossible to craft a form that everyone would be able to use. So again, instead, what we do is offer some tips. The first tip being that parties write down, very specifically how they've agreed to resolve the dispute. So who's going to do what by when. It's also important to note in there if there are any other pending processes. So if there's a due process hearing that's been requested, if there's an IDEA complaint or an Office of Civil Rights complaint that's been put in, if there's any other litigation about this situation pending, it's really important to indicate in the agreement how the parties are going to handle that. So are you going to withdraw your complaint or your due process hearing request since you've reached an agreement? You can include a statement that the parties agree to go back to mediation if things start falling apart. You should also include a plan for how you're going to share the information. It is not a best practice to just say, we'll staple the mediation agreement to the back of the IEP. No, instead, you want to make sure whoever is going to have some responsibility for doing things that come out of this mediation agreement, you've set up a plan. Who's going to talk to this person? Who's going to let them know what they need to do instead? The mediator should not be writing the agreement for the parties. That's not part of their role. And then once the agreement is written, only the parties are going to sign it. So that's the parents and the school rep. The mediator does not. One other important thing about these mediation agreements is while there is no form, there is some mandatory language that has to go into every written mediation agreement, and that is on your slide in italics. I'll read it to you. All discussions during mediation are confidential and may not be used as evidence in any hearing or civil proceeding. So that's the only required component to a mediation agreement. Once you have your agreement, please know that it is legally binding in Wisconsin. So if someone does not follow the agreement, you do have a legal cause of action under Wisconsin's contract law. But it's important for you to know that WSEMS is not the enforcement body. So if your mediation agreement is not being followed, WSEMS is unfortunately not going to be able to look into that, to require people to follow it. That's not the role of DPI either. We thankfully don't see a whole lot of agreements that aren't followed, and that's typically because it's the parties who came up with the terms of the agreement. So for the most part, people do seem to follow those pretty carefully. But even if your mediation does not result in an agreement, we see the process often helps the parties identify issues. And sometimes, even though you can't reach a full agreement, sometimes a partial agreement can be reached on some of the issues. For the most part, again, mediation is great, not just for coming to agreement, but hopefully in really trying to establish good communication for the long term. Just like with Nissan shared with you some statistics for facilitated IEP. Here are some statistics for the mediation system. As you can see, they're all pretty high. We have almost a 90% rate of agreement with our mediations. We've got really high percentages, 92% who would use mediation again, almost 91% who would use the same mediator again. And then you've just got a little bit of data on the average number of sessions and length of sessions, because that's kind of interesting too. So that wraps up the mediation option. I will turn things over to Nissan to cover the resolution process.
Thank you, Courtney. So far, we've covered then the IEP facilitation option, and Courtney just covered the mediation option. So this is the third option available to WSEMS. It's called the resolution process. So when parents file for a due process hearing, the school district has 30 days to resolve the issue to the satisfaction of the parents. IDEA 2004 federal law requires school district to hold a meeting with the parents called a resolution meeting within 15 days of receiving the notice of the due process hearing. In Wisconsin, the WSEMS can provide a neutral facilitator at no cost to parents and school to help with the resolution meeting if both the parents and the school ask for it. It is different than mediation because in the resolution process, there is no confidentiality provision for the resolution meeting. Participants in the meeting would include parents, school representative with decision-making authority, as well as some of the IP team members who know the issue that resulted in the due process hearing. School may not bring an attorney unless the parents bring an attorney. The slide that you have in front of you shows the waiver form on the left-hand side of the slide. If parents and school representative agree, they can sign the form, and instead of having the resolution meeting, they can go directly to a due process hearing, or they can go directly to mediation. If there is an agreement from the resolution meeting, it has to be in writing. If parents choose not to participate in the resolution meeting, the due process hearing does not move forward. As we move on to the next slide about our outreach. Courtney, Nalcinia, and I are the system primary outreach staff. We welcome requests for presentation to parents, school districts, blended audiences of parents and educators, professional organization, etc. The request form for training or exhibits can be found on the Forms tab on our WSEMS. And again, it is a free service. Our website is located on wsems.us. In that website, we maintain such examples as explanation of what is mediation. And by the way, I want to make sure you understand that there is a Spanish mirror image, and I believe we mentioned earlier Nocinia Ramos, who translated that. So the website includes such documents as explanation of what is mediation, who participates in mediation, the mediator's role, what is IP facilitation, who are the facilitators, how to prepare for an IP facilitation, how to contact WSEMS, also a list of roster mediators as well as facilitators, their bios and style of mediation, etc. Also, frequently asked questions on mediation, the WSEMS forms, publication, archive webinar like this one that we're doing right now, audio presentation, and other multimedia for 24/7 listening, as well as other resources. We also disseminate a great deal of WSEMS material, English and Spanish, through exhibits statewide or by mail as requested by different organizations, and all are free. As we move on to the next two slides, these are videos that in the interest of time we will not show, but they can be found on the Cadre website. So if you go to the wsems.us, our website, and you click on links and the links tab, you will be able to see, you reach the link for Cadre, and you'll be able to access those videos that include description of our system by Patty Williams, from Wisconsin DPI, and an interview that I held with Marshall Peter, the executive director of Cadre. Thank you, Courtney.
Thanks, Nissan. So that brings us to the end of the presentation. I'll pause for a moment if anyone has any questions that they'd like to put in the question box. I don't see that we've received any so far. While we are waiting just to see if anything comes in, I would just like to take this opportunity to thank my co-presenter Nissan Barlov, and to recommend if anyone has any questions about any of the options we covered, call that toll-free number for WSEMS, and Gia is going to be a wealth of information for you. Also, please do, in that follow-up email, please do take a moment to take the SurveyMonkey evaluation from today's workshop. So I am not seeing any questions. So at this point, I'm going to